services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters.
Hello. Good afternoon, good evening, good morning to everybody watching us from all over the world. You're welcome to hanging out with BWF Solicitors. I am your host, Vicky Newton. Today's topic is a child automatically British if their mother was married to someone other than their father at birth. And to take us through this question, the topic is lawyer Eunice Achampong, who is a partner and also a solicitor at BWF Solicitors. You can join us on Facebook, YouTube, all our social media handles live. You can also call us live in the studio on 0744-8619-711. The number again is 0744-8619-711. You can also WhatsApp your questions on this number as well. I will also entreat you to also share to all your contacts and colleagues. We would love to hear from you. Lawyer Eunice.
Hi. How are you?
I'm good, and looking sweet as always.
Thank you. And so are you. Valentine week, I'm liking the word as well.
Exactly. Yep. It's so interesting. Anytime we come in on live every Saturday, at this time, I do send out the question, the topic for today. And I tend to get a lot of people asking questions. I don't know whether they assume I'm also a solicitor. Please, I'm not.
I know what that feels like.
And, you know, some of those few questions that was asked was, does the biological father have to be named on the birth certificate of the child? And people were also talking about what the British Nationality Act 1981 says about a child whose mother was married to someone else other than their father at the time of birth. So I'm very, very excited. You're going to answer all those questions that was asked, because I told them, I'm afraid I'm not a solicitor. So,
Yeah.
lawyer, you need to be the right person to answer all those questions. But, you know, before we, you know, delve into this, if you could please give me an update, you know, this week, what happened? You know, what's the news flash?
Okay, so just before that, I want to wish you a happy belated birthday.
Oh,
I know you celebrated
thank
your birthday
you.
just before Valentine's, so happy birthday, and we pray that God will continue to see your heart and to see the desires that you have, and also to fulfill your purpose. We pray for good health. We also pray for Him to continue to grant you peace, for Him to give you that joy that you always have, and continue to shower you with His love. So we wish you a happy birthday.
Thank you. Right.
Okay.
You know, as we grow, we don't tend to be, you know, celebrating, making noise about our birthdays. So,
Birthday.
you know, it really exposed me. So I'm just next year, people will start.
Oh,
Hey, you just said a day before Valentine's Day is your birthday, but hey, I'll just enjoy it whilst it lasts.
I know. And also, we've been experiencing what Storm Eunice, and so yesterday
Oh, and
was.
that's you, isn't it? Oh no, you've broken my fence, my garden fence. I need to
Oh
come and see
no!
you. Yeah.
The number of people that called me and said the things that were happening around them, they said, "Oh my goodness, you've been terrible. How
You've
could
been
you
very
do this to
terrible.
us?"
Honestly, my back garden fence is off, so I think I need to send you a bill.
Oh, okay. So yes, I mean, to put it on a lighter note, I know it has been terrible, and
Yeah.
some people have even lost their lives yesterday due to the hemorrhage and everything that has been caused by this storm. And I'm hoping and praying that we will not experience anything like yesterday, today, and I mean the days ahead. So my condolences go out to those family members who have lost loved ones, and we're hoping and praying that the storm will just calm itself so that we can get back to some form of normality. So yes, please do take care when you're out and about, and just remember to keep everybody safe as well. Okay, so to our updates.
Yeah.
In general, I think that most of us know that when it comes to no recourse to public funds, anybody who has leave to remain in the UK will have no recourse to public funds. So you wouldn't have any access whatsoever to public funds, and you are expected to keep
Yeah.
working and to obviously maintain yourself and your family members. And so, of course, last year, when should I say 2 years ago in 2020, when we're hit by the coronavirus pandemic, a lot of people also experienced their jobs being lost, and so that
Right.
affected the incomes that were coming into homes and to families and the rest of it. And I think that most of the time, if you are in a situation like that, you are asking yourself, where do I get help from? And we thank God that we have a country where there is access to welfare benefits. And so, of course, they made it available to also the people that did not have recourse to public funds to apply for change of conditions so that they could also have access to public funds. And usually, if you're able to maintain yourself and meet all the other requirements, you are put on the 5 year route to settlement, which means that once you've completed a period of 5 years, you can then apply for indefinite leave to remain. But if, of course, you cannot maintain yourself and you can't also show that your income is sufficient to look after yourself and your family, then of course you can apply for public funds. And that meant that, of course, those people who were on the 5-year route will now have to be put on the 10-year route to settlement because they couldn't meet that requirement of maintenance. And
Okay.
so it was a question put to our immigration minister, Mr. Kevin Foster. And of course, if that meant that somebody who was expected to finish their leave to remain in 5 years' time was now going to have to complete 10 years of leave, then that meant that they were prolonging matters. And so our minister, Kevin Foster, said, "Do you know what? We're going to suspend that policy to obviously put those who are now on recourse to public funds on that 10-year route. We will now assess what their income is and how they can maintain themselves when they next apply for leave to remain. So,
Okay.
if, for instance, you were in that situation, you had leave to remain on the 5-year route, you had to apply for public funds because there was no way you could have been able to look after yourself and your family. But now you're back to work, you are earning the amount of income that is due you, you can look after yourself and your family. Then they will have to review it and see how best to obviously put you back. Because usually, once they put you on the 10-year route, it's as if they are saying you have to continue on. But if you do meet the requirements for maintenance, then they should assess you appropriately and hopefully put you back on the 5-year route rather than the 10-year route to settlement. So that's a good thing from our immigration minister. Coming back to our cases with our EU nationals as well. So I know that most people continuously want to find out what is going on with their applications that were made, for instance, for family members and extended family members who are outside of the UK, and whether they are granting them this family permit. Yes, they are going to grant them EU settlement scheme family permit rather than the EEA family permit. And so I know that, of course, there are some people who are asking why the long wait. Usually, once the decision has been made by the judge and they have to implement, the Home Office will usually have to send an email to the applicants to therefore go and present their passport at the visa center in Accra before
Okay.
their EUSS family permit is issued. That can take from a few weeks to even 3 to 6 months. So, depending on the caseworker working on the case, please be rest assured that they will get back to you. They will listen to what most of us are saying to them and will implement the decisions as soon as possible. So, it is still ongoing. People should not be so worried, should not be apprehensive, but they will issue those EUSS family permits as soon as they can. And last week, I know we were talking about those who made applications under the Zambrano.
Yeah.
So, yes, a lot of people were still asking, is it possible for me to make the Zambrano application now that the case of Akinsanya has been decided? And of course, now that it has been decided, the Court of Appeal hasn't given everybody who has two and have the right to make a Zambrano application. So we must be careful because, of course, it is applicable to some and not to all. And so
Mm.
I know that in that case, the Court of Appeal was very decisive about the fact that when it comes to the immigration rules, which is our British immigration rules, if there is law in regards to family members, such as parents, who are able to make the application either as a sole parent or as a parent who normally lives with the child or as a parent who has direct access, then of course the whole intention of the ruling in Zambrano was to make sure that those people who could not apply under our immigration rules will then have a means of applying to be able to reside in the UK with their British child. But if there is some provision in our immigration rules, then there shouldn't be the other option of that person applying under Zambrano. So, of course, if you're a parent and you know that you are the main primary carer of this child, for instance, you and your husband have no leave to remain whatsoever. You are not the sole parent because you are joint parents. And of course, when it comes to the fact that the British child will have to leave the UK, yes, the British child will leave the UK if the two primary carers or the primary carer is not available to look after this child or to care for this child. And so that meant that, of course, those parents or parent who come under that category will then be able to eligibly apply for the Zambrano derivative rights, which they will be granted 5 years leave to remain, and then after the 5 years, indefinite leave to remain. So, yes, if you have 2.5 years and you are thinking to switch, please don't switch. Just go ahead and apply for your next 2.5 years leave to remain, unless you believe that there is means by which you meet the requirements under the Zambrano derivative rights. So yes, that's for those who are applying for Zambrano derivative rights to remain. And lastly, our care workers. Is always good to have the care workers that we have here in the UK. Um, very often I hear that because of the fact that some people do not want to take the vaccination, they are losing a lot of care workers. So not just in the hospitals, but also in the care homes, in the nursing homes as well. So they are constantly looking for care workers, care assistants to obviously take up these positions. Of course, they have their own policy and guidance, but it is good that now the government has seen it fit to specifically mention care workers, care assistants, etc., on the eligible occupation list, which makes it much easier for employers to basically specify that these are the workers they are looking out for. So yes, that's
I think
also
previously the focus was on only the NHS staff, isn't it?
yes. So it was mostly on things like nurses, doctors, and then health professionals. Health professionals is such a wide and broad
Broad.
term. So now that they've made it very specific, it helps that now we can specifically mention these workers in our applications. Yeah.
Oh, okay. All right. Brilliant. So if you've just joined us, this is Hanging Out with BWF Solicitors. BWF Solicitors is your number one law firm in UK. They've won so many awards. Their success rate is, amazing. People are referring their friends, loved ones, and colleagues to BWF Solicitors. BWF Solicitors is also doing a lot for the community as well. They are specialists in immigration and nationality, Ghana law and practice, family law, dispute resolution. If you have any problems or any, you need any support or help or advice in these areas that I've mentioned, which is their specialty, look no further. BWF solicitors will be there to help you along the way. I would like to get more questions from you. If you prefer to call us, you can also do that on 0744 8619 711. You can also send your questions through WhatsApp. Please send in all your questions, because I think with your questions pouring in will make this discussion more interesting. We don't want it to look like it's only Lawyer Eunice, talking. At least I need your input. And that's why Lawyer Eunice is here. And the good thing is that this is free consultation. If you should go to a solicitor and, ask your questions, you definitely be charged for consultation. So take this opportunity, send in your questions, call us, or send in your questions through WhatsApp, and Lawyer Eunice will be very happy to answer your questions. I would also like to state that whatever is being discussed here shouldn't influence you to put in an application by yourself. This is just a guidance. So if you decide to go ahead with your application, after listening to this program, please contact Lawyer Eunice. She will leave her details at the end of the program, and she'll be able to guide you, because I believe that even though this program is generalized, we are focusing on a particular topic, but everybody has a specific requirement. So please, 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 after the program, if you need any support or help, don't just go ahead and put in the application based on what we've discussed today. Contact Lawyer Eunice, and she will be able to look at you, be able to help you according to your specific requirements. So that is it. Today's topic, for those who have just joined us, is a child automatically British if their mother was married to someone other than their father at birth? So, Laura Eunice, to jump into this, discussion, what does the British Nationality Act 1981 say about who a child's father is? If their mother was married to some other than their father. I think this question was asked me just yesterday. So I think that's the first thing I want to ask you.
Okay. So generally speaking, when you look clearly at sorry, I can hear some feedback. Let me just
No problem. No problem.
okay.
Yes.
I hope this is better. So,
Yeah.
generally speaking, when we look at our British Nationality Act 1981, it was, as should I say, a backdrop to our British Nationality Act of 1942, which allowed a lot of children who were born here in the UK to obviously be automatically British as long as you were born in the UK. You had that automatic right to be a British citizen. But the 1981 Act changed all of that. And the 1981 Act came into force in 1983. So when the Act came into force, any child who was born on the 13th of January 1983 would no longer be seen to be British. They would have to register, or they would have to have parents who were settled here before they would be able to gain British citizenship. So the 1983 81 Act basically brought into force a new regime for people to now call themselves British. So if a child is to be a British citizen, then it would mean that their parents were settled here in the UK, or they were British themselves. Or if a child was born outside of the UK, then it would mean that their parents would have had to be British before they were born, or by the time they were born, so that they would also be able to be granted British citizenship by descent. So if obviously a parent gave birth to a child and they were British, the child who was born here in the UK will also be British, and
Mm,
so on and so forth. So as long as you kept giving birth to your children here in the UK, you would continue to be British. But
mm,
if the child, obviously outside of the UK, was born to a parent who was naturalized, for instance, they would be British by descent. And then the child who is outside of the UK, if they were to have another child outside the UK, they would not be able to um, say that they were British because it wasn't automatic. So, in terms of children who were born to their mother or to their father um, outside or within the UK, if their mother, for instance, was born here, or their mother was born in outside of the UK, so long as they were able to show that one parent, for instance, was British or settled, they will be able to register the child, or the child will be able to become British if the parent was British or settled at the time they were born. So, for example, if I decided to have my child and I was not a British citizen, but my husband was a British citizen by the time I gave birth to my child, but
Mm.
my husband, obviously, in quotes, I'm married to somebody else for the purposes of gaining status here in the UK. So, my husband, who I have decided to say is the child's father,
Mhm.
it has British citizenship. And the one who is my husband by registration or on paper um, doesn't necessarily have British citizenship. Maybe he might have indefinite leave to remain
Mm.
or whatnot. Because Section 59A of our British Nationality Act describes who a father is for the purposes of nationality, it says that if a child's mother was married at the time of the birth of that child, then the person that she is married to is the child's father. So obviously, when you look at that, then it means that the person that I have married on paper is the child's father, whether his name is on the birth certificate or not, he is
Okay.
the child's father. And that's what the law states.
Mm.
Unless, obviously, I had the child by IVF. So if I had a child by IVF, then it is not going to be stated specifically who the child's father is. But yes, apart from those two reasons, if none of them apply, if I was not married, or if, for instance, I didn't have anybody at the time that I would say was my husband, then it would mean that the child whose parents is listed on the birth certificate will be the child's father. So, in essence, what the law is saying is that we don't want to have bastard children. We want every child who is born to have a legitimate parent, and that's why we have that section under the law.
Okay, all right. Akosia is saying, does the biological father have to be named on the birth certificate?
So, in essence, if, for instance, you're saying that the biological father is Mr. Sumedu, and Mr. Sumedu is on the birth certificate,
Yeah.
then that's good. But if for one or two reasons you are not sure whether to put his name on the birth certificate, and you now want his name to be put there, you want it to be known that he is the father, so that you can go ahead with the application. Then the other option will be to have a DNA testing done, or usually there are court orders like a declaration of parentage, which will state clearly who the child's father is. And so, of course, if there is DNA evidence to support the fact that Mr. Asumedu is the child's biological father, then that can also be used as evidence. So it's not just the person named on the birth certificate. You can also have DNA evidence as well, or a court order which shows that declaration of parentage as well. So either of those can be used as evidence that this is the child's biological father. Yes.
Okay, all right. Um, Laura Eunice, does it matter if the child was born outside the UK?
So, not in this case. I mean,
Yeah.
like I was saying to you, when it comes to whether a child is British or not, there are those that will be born outside the UK, and there will be those that will be born within the UK. So, if a child was born outside of the UK and their parents did not obtain British citizenship by descent. So, what I mean by that is, if a parent, for instance, naturalized and they had a child outside of the UK, and
Yeah.
obviously they decided they wanted to pass on their citizenship, they could pass on that citizenship under Section 2 of our British Nationality Act. So that is allowed. But if, for instance, this child who was born outside of the UK had a wife and also had his children outside of the UK, that child who was born and is now a grown man will not be able to pass on his citizenship to his children because unfortunately he was able to obtain it by descent. So he was able
Okay.
to get his citizenship because of his father. And so it was passed on to him, but he can't pass it on to his children. So in
Mm,
that case, of course, he will have to have come to live in the UK and then have the children have indefinite leave to remain before he can register the children to become British. So if the child was born outside of the UK and their parent is not one who was able to gain British citizenship, not otherwise than by descent, then yes, they can pass it on to their child who was born outside of the UK.
okay. I've got someone on Facebook asking. My father is a British citizen, and I'm now 36 years. Does that apply to me?
So, of course, even if you are 50 years and your dad was a British citizen at the time of your birth, then yes. So, for instance, like I was saying, somebody who was born, let's say, in 1985, because of course their father was British or their mother was British at the time they were giving birth to, that would mean that the
Yeah.
child could also recognize themselves as automatically British because at the time their parents gave birth to them, they were either settled or British at the time. And so that child will also be automatically British. So, I mean, the child is still British, especially she's what, 36? So I'm
6,
guessing,
yes.
yeah. So I'm guessing, of course, this was in the 80s. And so, yes, that would apply to them as well.
Okay, right. Ladies and gentlemen, this is Hanging Out with BWS Solicitors. If you've just joined us, I'm here with Lawyer Eunice, Mrs. Lawyer Eunice Achampong. She's a partner and also a solicitor at BWF Solicitors. And today we are talking about a child automatically being British if their mother was married to someone other than their father at birth. If you have any questions on this topic, please do so by sending us your questions on Facebook, YouTube, and all our social media handles. If you prefer to call us live in the studio, you can also do that on 0744 8619 711. The number again is 0744 8619 711. I think in 5 minutes I'll be taking phone calls. So if you want to send us, call us live in the studio, you can do so in the next 5 minutes and I'll pick as much calls as I can. Lawyer Eunice, wow. This gentleman says he doesn't want his name to be mentioned, wants to remain anonymous. He says, "Good afternoon, Lawyer Eunice and Vicky. I applied for British passport for my child who was born outside the UK. It was rejected because I was interviewed and um, I was interviewed. So was the child's mother. And it was clear from what we told them that she was married to someone else at the time we got together. She got pregnant. I was British. I was a British citizen before the child was born. Sorry, we would like to find out if we could register him instead."
Okay, so this is one of those scenarios where, of course, somebody has had to do something. Either it was an affair or she's left her husband and has
Yeah,
not yet divorced. And so is obviously thinking, what do I do now that I have this child?
yeah,
It's interesting that he also mentions that the child was born outside of the UK. So, of course, in a scenario like this, you would think that because he is British, he could then
Yeah.
automatically apply for a passport for his child
Yeah.
because he was
Yeah.
British before the child was born. But it is not so because, like I've just mentioned, because Section 59A specifically mentions who a child's father is for the purposes of nationality,
Yeah.
he will not be able to apply for the passport directly for this child because now we've got evidence that the child's mother was married to somebody else before
Else. Yeah.
she had this child. And so it means that everything will have to be put on hold in terms of making that passport application for the child. So now they would now have to register this child, and um, this is a discretion which the Home Office offers. So they have their own policy guidance in regards to such applications, and that is the UKFM form or guidance for
Mhm.
caseworkers to look at. And it's interesting that they mentioned that as long as the child does not have any British citizenships whatsoever, so if the
Yeah.
child has not obtained British citizenship whatsoever. And if the child can show that if their mother were not married to somebody else, then their biological father would have been their father for the purposes of this British citizenship application. So,
Okay.
in such a scenario, they are saying that yes, we realize that this child should have the right to be registered as British. And we know that the law is hindering them from making such an application. But we will use our discretion to say that, yes, you were married to somebody else. But because, of course, we know that this child's biological father is also a citizen who can pass on his citizenship to his child, we will look at it in that respect and then um, try and grant this child his citizenship by way of
Mm.
registration. So it is
Mm.
the Home Office using their discretion or the Home Secretary using her discretion to grant this child citizenship in order for them to not miss out on what would have been their right. So this section of the law only came into force in 2006. So before
Mm.
that, it would have been simple to just do the do the passport application, and that was that. But since 2006, it became apparent that they didn't want other children who were called bastard children to lose out, and that's how
Yeah.
this law
Yeah.
came into force. So it's a good thing that now this parent can apply for registration rather than the passport application, and they would then use their discretion to
Right.
make sure that this child has their citizenship granted to them. So they will give the child a certificate of registration, which would then be used to make the passport application.
Right. Yaron Nima is saying that she is a British citizen, but had her children in Ghana, and their ages is under 10.
Mm.
Can they also claim British citizenship?
So it depends on whether she also had her British citizenship before the children were born. So yes, her children are under 10, but it's
Mhm.
more to do with the time they were born. So if she was British before the children were born, then automatically the children will then be seen as British.
Mm.
Um, Before the 1981 Act came into force, it wasn't easy for women to pass on their citizenship. So it was seen to be the right of the man to
Okay.
pass on his citizenship to the children. But of course, as of now, it makes sense that women should also be given the right to pass on their citizenship. So if the child was born after the 1981 Act was enforced, which is, she says they're under 10, so they are
Yeah.
millennial babies. So if they are millennial babies, then of course, if the mother had citizenship before the children were born or at the time the children were born, then the children could also become British automatically. So even though they were born outside of the UK, she can pass her citizenship on to her children, which means that they will be British by descent. Yeah.
Okay. I think we can quickly have a short break. Please
Okay.
stay tuned. We'll definitely be right back. Don't go anywhere.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Welcome back. Welcome back. This is Hanging Out with BWF Solicitors. I'm your host, Vicky Newton, and with me is the Leonard solicitor, female solicitor. Should I say very young female solicitor? And partner at BWF Solicitors, Mrs. Lawyer Eunice Achampong. She's here with me today. We're discussing a child automatically being, being registered British if their mother was married to someone other than their father at birth. If you'd like to send in your questions, please do so on our social media handles, especially Facebook and YouTube. You can also call me live in the studio on 0744-861-9711. Also send a WhatsApp on the same number, 0744-8619-711. Laura Eunice, you're welcome back.
Thank you.
Right. Laura Eunice, what would it make a difference, if I should say, if the mother has indefinite leave to remain before the child was born in the UK?
So if, for instance, a parent has indefinite leave to remain, very similar to the question we had before we went on a break, if the parent was either British or had indefinite leave to remain, as long as there is that option of the parent making that registration for the child or applying for a passport for that child. So if that mother had indefinite leave to remain and at the time she had the child, she was already settled, then she can make the application for the child. It's to do with the fact that, of course, if the child is born outside of the UK, they don't just look at settled status, they look at British citizenship. So you would have
Okay.
to say that you were British at the time the child was born before you can then apply for the passport for the child directly. If the child obviously was born in the UK, then the settled status is fair. It's okay to be settled at the time the child was born, and then you can apply directly for the child to be British. Um, if, for instance, at the time he was born or she was born, you had not yet gained your indefinite leave to remain, or you were not yet settled in the UK. If later,
Mm,
of course, you are now saying that you've become settled, so you've now got indefinite leave to remain, and you're now
mm,
making the application, then they'll be looking at whether that child's father had British citizenship at the time
mm,
the child was born, and will be basing their decision on the child's father's status, so that they can
yeah.
then decide the application. But if,
Mm,
of course, at the time the child was born, the mother was
mm,
already settled, or the mother was already someone
mm.
with indefinite leave to remain, then she
Like,
could.
just bear with me 1 minute. There's a phone call
Okay.
that's coming. If you don't mind us, yeah, so that we can go back. Hello, caller. Hello.
Hello, good afternoon.
Good afternoon. How are you?
I'm all right.
Okay.
I
What's
just
your
have a
name?
question for our
Ye-
solicitor for
Yes.
today.
Yeah. What's your name and where are you calling from, please?
I'm calling from Liverpool.
Liverpool. All right. Your question.
Yes, my question is regarding I was Yaro Nima on which stated some question about my kids. I have 4 kids. They were all born in Ghana, and had my citizenship before they were born, and I tried to apply for them, but I was a bit confused because I spoke to one solicitor. He said, yes, I can. And I'm hearing a different thing from my sister here. So I'm not too sure if which steps I should take, because I already applied for my missus, which she'll be coming very soon
Okay.
as on spouse visa.
Okay.
But for the kids, I'm not too sure. Even if I wasn't able to apply for them the British passport, which
Other
I think
alternative.
coming with a 2.5 years visa or what? That's what I want, or indefinite, because someone said I can apply indefinite for them.
Okay. All right. Laura Eunice, did you get the question?
So how did he become British? Can I ask him?
By naturalization.
Okay, so if he became British by naturalization and he has children who were born outside of the UK, as long as he had citizenship before the children were born, the children are automatically British. So if, for instance,
I had my nationality after before they were a bit confused. I had it after they were born.
Okay. He had it after they were born.
Okay, so if he had it after they were born, then they are not automatically British. So that would mean that he would then now have to make the application for them to come and join him. And once they've got settled status, he can apply for them to be registered as British citizens if they are still children at that time. So it is about what citizenship you had at the time they were born.
Yeah.
Okay. So now, which application can I do? Is it the same like their marriage, or like the 2.5 year, or the indefinite? That's what I want to know.
Is it for the
It
kids?
will be the same as what their mother has. If, for instance, their mother was not in the picture and you were saying that you are the sole parent who is responsible for them, then you would be making an application for indefinite leave to remain. But because you are married to their mother and you want to bring their mother, it will be the same application as their mother. So 2.5 years.
Oh, so how about after the 2.5 years? would they go straight to indefinite, then the nationality, or straight to the British passport? I'm not talking about the mother, I'm talking about the
The
kids.
children.
Yes, so it will be in line with their mother. So when you look at Appendix FM, if you're making a spousal application and the person meets all of the requirements, they will be granted 30 months twice for that period of time. We usually say that it's a 5-year leave to remain. So if you're put on the 5-year route, then it means that after that 5-year period, you will be granted indefinite leave to remain if you continue to meet the requirements. So if the mother is given 2.5 years and then another 2.5, the same will be applicable to the children. They will be given that same period. And then once the mother is applying for indefinite leave to remain, she would do the same for the children as well.
Okay. All right.
Thank you very much.
All right. You're welcome. Yeah. So if you need any further, guidance, Lawyer Eunice will leave her details at the end of the program, and you can give her a call. All right. Thank you for calling.
Thank you very much.
All right. Thank you. Yeah, Lawyer Eunice.
Yes. So I was saying that in regards to the question about whether the mother could apply for them, just as he has also mentioned, if the settled status was after the birth of the children, then of course she can now register the children to say that this is what I now have. But they will always look at the status of her husband at the time the children was born. So regardless of whether she now has settled status, they will go back to check, okay, if your husband already had indefinite leave to remain or British citizenship at the time the children were born, then the children are British by way of your husband being British. So regardless of whose name is on the birth certificate, they are looking at her husband. And if she were the one who had indefinite leave to remain or settled status before the children were born or at the time the children were born, then she could have automatically applied for the children to be given British passports. So it's very close call when you are looking at whether they were British at the time that they were born or whether they would have to register before they are able to gain their British citizenship. So I think it's a good thing that this man has come to clarify things for us. Yeah.
Lioness, I've got another phone call. Hello, Mommy. I think she wants to speak to you.
Okay.
Yes.
Mommy, I'm quite bold. Pacha, who free for here? Okay. And then, Mommy, Pacha, what question for Lawyer Eunice?
Further leave to remain application, but Miss Silly, and said, we didn't say, I'm mammy, me banner details. As previously, me, and mammy, the details, me, dean, me, but we are mammy. The details into the I said, me, convinces right from the feeling and I say, and I'm my Katrana too. But I use the program into
okay.
When friends say, or bet me up one make a car.
Okay. And say I think the way I over to me, I and say so all further leave to remain from now. Am our options into Rebecca options need to say child, parents, partner, private life. Into you have to make sure say you are clicking the option which says that you are a parent. It means that of course all fill application now. A baby all applicants with details. Yeah, a baby say in Kolana. If you have children, not what fill in Kolani details, no, and that same application. It depends on the option now what we choose it. And I think because obviously I can't see the form all I can do is guide you into making sure fill it FLR FP and now I click it option now I can parents, not partner.
Oh, okay. Okay, where do I make to see child?
So child, dear, only back child, my child. It's our top parents. Who click parents? We your parents, not just a back. Into no more options. Say okay, we your parents are color ni details into a baby.
Yeah.
Say have our body details I share. Me pa what you say. Okay, all right. But so bibi chire wa adwen a as a wo fill form bibi chire wa adwen a lawyer Eunice beja ne details ye wie program na wa frɛ no na wanya botra ma na wa cheche bibiem na we hu sa ade a wo ye no ne kwan so ano no. Why?
Oh, I'm so grateful.
Okay, all right.
You all right. Okay, lawyer Eunice number.
Me pa cha wa enche be wie sesi anti wo de koso hwɛ program no obeja ne number. Why? Okay, yeah, that's a friend. Okay, bye bye. Oh, no crap. No crap.
Amen. Yeah, that's
Amen. Yeah, that's it. Okay, all right. Bye bye. Bye.
Bye.
Right, Lawyer Eunice, if for the benefit of those who don't speak the local P dialect, if you could please just give an idea what the woman asked and your answer to that question, please.
Okay, so she was asking about her application for further leave to remain and the fact that when she went through the application, it didn't ask for her children's details, and she was quite worried and wanted to find out if she was completing the right form. So I've just said to her that when you are completing the further leave to remain, which is the FLRFP online form, you have to be careful which option you choose because they will give you some options from which you can choose and obviously make known where or how your application is being made. So there's a child, the parents, partner, private life, and I think there's one more that I've forgotten. But she had clicked on the child option, and so it wasn't giving her any questions in regards to her children. Instead, she should have clicked on the option as a parent because she is a parent to the child she is seeking to rely on. And so be careful when you are clicking on the options because I know people who have filled in the application, choosing the wrong option, and once it has been submitted, of course, it is deemed to be submitted once you've made payment.
Yeah.
If for any reason you have your leave to remain ending at a certain time and you don't realize this mistake, it means that your leave would have come to an end and you haven't made a valid application. So we have to be careful because if you haven't made a valid application, it means that you have become an overstayer. So it is very necessary that you know that you are filling in the right application before you go ahead and click the submit button, because once that's done and your leave is rejected as invalid, it means that you are now an overstayer. And if you're on the 2.5 year route, it means if you haven't met the requirements of making the application within 14 days of your leave expiring, you are definitely causing yourself a lot of trouble. So it will be like you starting all over again. So it's very, very important when making these applications. Yeah.
Right. All too soon. Our time is up, Lawyer Eunice.
Yes, I know.
Thank you for answering all the questions. I believe our viewers as well are satisfied with everything discussed today and all questions answered. So, Lawyer Eunice, if you could briefly give us a brief what has been discussed so far and also your contact details so that the last caller who called is patiently waiting for your contact details.
Okay. So, yes. Of course. Very briefly, we've just been discussing what it means to go ahead and register your child as British if for one reason or the other you as a parent was married to somebody else other than the child's father. And so of course, looking at section 59A of our British Nationality Act, a child's father is the person the mother was married to at the time of their birth. If for any reason, of course, you are in this situation and you are thinking, how then can I have my child become British because their biological father is British and their my husband is not. So how do I go about this? And so it is important that you also realize that they can register them under Form UKFM, and that is the discretion of the Secretary of State to then go ahead and grant this child a registration certificate to then become British if their biological father is British and the said husband or partner is not a British citizen. So yes, there is means by which they can apply for registration, and they can therefore seek legal advice for that application to be completed. As we always say, it is not just immigration or nationality that we deal with. We also deal with other aspects of the law, including family law, in regards to those who may be facing some form of harassment or abuse. We deal with non-molestation orders, divorce, child arrangement orders, and also civil litigation matters when it comes to cost or debt that is owed to you. We deal with that as well. So we are situated in London. As a firm, we work either remotely or face to face. You can instruct us to deal with your matter either via our social media handles, so Zoom, WhatsApp, and the rest of it, or you can come into our offices by booking an appointment, and we will definitely see to whatever inquiries you have and show you how best we can assist you. We are at Seven Sisters, 4th floor of Anna House, 214 to 218 Tottenham High Road. The postcode is N15 4NP. So it's N15 4NP. And our contact number for the office is 0208 493 7340. So 0208 493 7340. And my number is 075 35 81 3910. So 075 35 81 3910. Thank you so much, Vicky.
Thank you, Lawyer Eunice. Oh, ladies and gentlemen, as I said, we've come to the end of the program. If you want to contact Lawyer Eunice for further advice, she's left her details. If you joined us in the middle of this program, we have a recorded version. You go to BWF Solicitors on our Facebook, YouTube page, and you'll find the recorded version there, and you can, watch from the beginning. Thank you so much for staying with us throughout this program. We appreciate you so much for being part of this program every Saturday from 1 p.m. We are not taking this for granted at all. So until then, from me, your host, Vicky Newton, and Lawyer Eunice Acheampong, we will see you again same time next week. Stay blessed.
Bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.